This week we're discussing asset protection and specifically how it relates to retirement accounts. This is Estate Planning Weekly, episode 19. I am your host, Don Rolfe. I'm the owner and founder of Northwest Legal Planning and Estate Planning and Probate Law Firm located in Westland, Oregon, and serving the greater Portland metro area. Retirement accounts. Everyone works hard, you work hard, and you've managed to save some money in a special 401k, traditional IRA, Roth IRA, perhaps you're self-employed and have a SEP IRA, some form of retirement account where you've socked away money and perhaps your employer has also put money in there for you. And that money grows tax-free until you take it out and you start paying taxes on it at that point. Unless, of course, it's a Roth IRA where you've put after-tax dollars in and then you get to make those withdrawals without a tax on them. But regardless, when you have that money set aside, it is protected under the law from creditors and bankruptcy. So there's no attachment. It's a special type of money, unless there's some strange fraud going on where perhaps they're going to be able to get at that money. It's pretty much protected. And if your spouse inherits that money from you, they're going to maintain the same protection that you had during your lifetime. And the reason for that is that the government, in all its wisdom, has decided that, spouses save their retirement not just for taking care of themselves after they're done working, but also taking care of their spouse. However, they don't really give a care about anybody outside of the marriage relationship. So children, other family members, or non-related people that inherit an IRA from you are oftentimes not afforded those same protections that you were afforded or your spouse would have been afforded. Now, those protections do exist to some extent, and maybe all the way that you would have had, and maybe a little bit less in a handful of states. However, Oregon is not one of them. Here in Oregon, a retired IRA or an inherited IRA or retirement account is open to creditors and would become part of a bankruptcy estate if your heir needed to file for bankruptcy in the future. So, how do we protect this asset from potential creditors, predators, exes, bankruptcy? Well, we can leave the trust or leave the IRA instead of to a individual. We would name a trust for them. And we design a special trust such that the person you're leaving it to is the only beneficiary. They do not have rights to withdraw money from the retirement account. The only right that they have is to receive the annual required minimum distribution from the retirement account. So the retirement account pays the required minimum distribution to the trust, and the trust immediately pays it out to the beneficiary. And the reason we do that is that creditors and others only have the rights to that account that the beneficiary has. Well, in this case, we've designed the trust in such a way that that beneficiary doesn't have the right to go back upstream and get the money out. It's up to the trustee that you've appointed. And by doing this, we're allowing that money to remain protected for the rest of the beneficiary's life. And while a lot of people might think, well, how common is it that something's going to happen, and is that money really going to be opened up to creditors and be taken for something that you never intended? And the truth is we just don't know. Anything could happen. It could have been an at-fault auto accident, where someone died, got hit a pedestrian, and they get sued, and that IRA could disappear real quick if it's an inherited IRA. But whatever the case, and whatever the odds, it's a pretty quick and easy solution to name the trust as a beneficiary to give those protections. Now, there are certain things that have to be written into the trust. It has to be written correctly in order for this to all work. but that's something that that I can definitely handle for you, and it's something that I do for a lot of my clients. So if you have a substantial retirement account or accounts to make up a bulk of your estate and make up a bulk of what you may be leaving behind for your children, then I would definitely consider looking into either naming a revocable living trust, a separate share that you create for your child, as a beneficiary of your retirement accounts, or setting up a separate retirement account trust specifically for that purpose. If you have any questions about protections that you can put in place for your retirement accounts, please do reach out to me. I'm happy to answer any questions. You can schedule a telephone or in-person estate planning strategy session and ask me anything that you would like by visiting my website or clicking on the link below this video. Until next week, take care.